Michelle asked me to give an overview of what local government can do in this area in the way of regulation. And when lawyers talk about authority and regulation, they like to start with the Constitution. And this first few minutes is very introductory, sort of basic, but as Michelle mentioned, in my involvement over at Wall Lake, when we worked with the Township Board on regulating or attempting to regulate blood bogging, some of these concepts got mixed up and were confusing to people, so I thought I'd take a minute to just walk through these. So the Constitution provides that local government has certain authorities and powers. So when I talk about local government, I'm going to talk about counties, townships, cities, and villages. They're all creatures of the Constitution. The Constitution establishes them and sets them up. And in each of these, a couple of slides. And by the way, I brought copies of those. I was here a little bit late, so a lot of you were already here by the time I got here. On the back table are copies of this. They're handed out. Great.
Maybe some more copies. So if you didn't get a copy, you should be able to get a copy soon.
Great.
So each of these local units of government, counties, townships, cities, and villages, are all referenced in the Constitution and all are given powers and immunities as provided by law. That's the phrase that's used for each of these municipal entities. And what that means is the legislature, the state legislature, adopts specific statutes that delegate power to municipalities. Municipalities are really just a subset of state government, and they only have whatever authority that the state legislature granted them. And we'll go through some of those grants of authorities in a minute. This last constitutional provision I put up because in my work, this is something that often is done at the local level, and municipalities are very protective, as they should be, of their public streets and alleys and public places. And the Constitution does guarantee that businesses have to work with local government before they can utilize the public places, either through getting the consent to operate or to get franchises. But that right is going to be very limited in our discussion today, because as you'll note in the slide, here and here, this franchise provision applies to public utilities. And most of the oil and gas operators that you're going to see or run into aren't going to be public utilities. They're going to be private companies that are trying to produce oil or gas for a profit. And so they aren't subject to this. Now, this last provision, however, the reserving to local governments reasonable control over their highway, streets, and public places, that is a constitutionally guaranteed right for local government. Local government is not required to allow private businesses to put their oil or gas lines underneath their streets. But having said that, they can't discriminate between the oil and gas industry and other businesses. So, for example, local government can't allow cable TV or phone companies to run their cables under their streets, but then tell an oil and gas operator, you can't use our streets. So now let's look at what has been, what the state legislature has specifically authorized local governments to do. And this is sort of right in the area that caused some confusion over in Hope Township. The legislature has adopted statutes that fall into two different categories. One are very specific authorizations. I've listed the Zoning Enabling Act there as probably one of the prime examples for local government. zoning authority is one of the strongest tools that local government has to regulate businesses. So the Zoning Enabling Act gives counties, townships, cities, and villages the right to adopt zoning ordinances. There are a lot of procedures built into the Zoning Enabling Act. Before a local government can adopt a zoning ordinance, you have to set up a planning commission. They have to develop a plan. The zoning ordinance has to be based on that plan. Once the ordinance has been adopted, and there are very specific procedures that have to be followed to adopt the ordinance, then there are other very specific procedures that have to take place in order to amend that ordinance. So a local government may have an ordinance in place when a new business decides to come to town. Call it mud bogging, call it whatever you'd like, but a new business that hasn't been regulated in the township zoning ordinance or city or village or county ordinance already. Well, local government can amend that ordinance, but they have to go through certain procedures. And lawyers representing these businesses, and I do that on occasion, have ways to sort of drag the process out. If the process gets dragged out and the business establishes itself through substantial construction, then the zoning ordinance can't prohibit it once it's been adopted or amended. The Zoning Enabling Act has a provision in the state statute that says when local governments adopt a zoning ordinance, they have to include in that ordinance a non-conforming use rights section. So any use that was valid and existing before the ordinance was adopted or amended to either regulate it or prohibit it, it's not effective against such uses. So that's one of the drawbacks of the Zoning Enabling Act, but that's a situation or an example where the state has legislated specifically that local governments can essentially occupy the field in this area. Zoning is a local power in Michigan. The state does not regulate zoning. It's delegated that down to local government. The other type of legislation that the state adopts is called, in the industry, it's called police power. Now I've listed there the county, township, home rule cities. In each of these areas, actually the villages as well, each has a statute that the legislature has adopted that gives them broad, what I'll call police power authority. And that's that they have, generally speaking, they have the authority to adopt ordinances and otherwise regulate if it benefits the health, safety, or welfare of their citizens. So that's very broad. When local governments adopt ordinances pursuant to that police power grant, there are no non-conforming use rights that attach. So local governments have building codes as an example. Building codes are necessary to protect the health and safety of occupants of buildings within the local community. If those codes change, they apply. And there's no grandfather or non-conforming use rights that attaches to them. So a local government can adopt a zoning regulation, they can adopt a police power regulation, and there are different effects with each of them.